again, guys. Merry Christmas. It's Kathy. I hope you're doing well. Hope today's going really great for you. I have a quickie. I just have a Christmas quickie. Um, and let me set the stage real quick because I didn't get the whole thing. I only got the good part. So, an inmate is here for a plea. So he's in front of the judge. Um, he's pleading guilty, and when an inmate pleads guilty, the judge goes through. Well, if you plead guilty, you're giving up this right and this right and this right. This can happen to you and this can happen to you. So the inmate is listening to the judge go through that whole spiel and absorbing it all. And then the judge says, well, do you have any questions? And that's when everything breaks down. And this inmate is mad at his lawyer. He wants her gone, period. So let's get going.
So, any other questions about that, or?
I have another question.
Okay, sure.
If you're done with this part.
Yeah, sure.
I'm not completely understanding the terms of the concurrent, how that's calculated.
Okay. Yeah, so concurrent means that they're all served at the same time. And as I understand it, with regard to the two cases that you were in community corrections, I would have to resentence you for those counts. And then if you plead guilty in the 24 CR case to leaving community corrections, that unauthorized absence, all three of those sentences would have to be served at the same time.
Would I get credit for what was served on all of them?
So what happens is that the court makes a finding as to the amount of pre-sentence confinement. So I wrote down some notes based on what community corrections filed. So in 22 CR 1381, as of September 3rd, they wrote that you had 654 days. And the other case, they wrote that as of September 3rd, that's the date that they're saying you left the facility, you had 545 days. And then I didn't calculate any pre-sentence confinement for the 937 case, but I know that warrant, at least the court file indicates that warrant was executed, the arrest warrant, on September 10th. So there should be pre-sentence confinement credits in September 10th for that case.
So that's what would be applied to the concurrent range of what was served on that sentence?
So it gets a little complicated. So if you were sentenced to prison, I just make a finding of pre-sentence confinement. And then the Department of Corrections has all kinds of regulations that they use. And so if they have to apply it as following those regulations. So I hate to tell you that you would get credit for all of that because they may consider you having they may make you serve those other ComCore sentences first, but I think it would all be served at the same time, but I'm just not sure. So what I would tell you is that I just make the finding of pre-sentence confinement. And then if you think that DOC is not giving you, and that's if I sentence you to DOC, that they're not giving you the credit that you're entitled to, when you think you're supposed to be released, then you could file a request with the court to be released.
So I'm asking just one more time.
Yeah, no worries.
If I was given credit in the case for the concurrent sentence, does the credit apply to every charge the same, or is it different depending on conviction date?
It's going to be a little bit different for you because I think you were, I have different dates that you were incarcerated for based on the community corrections. So sorry. So for the 24 CR case, the leaving community corrections case, as I mentioned, that could be as little as 15 months, but it could be for as many as 36 months. And I know that your community correction sentence, at least for the menacing charge, that was for 3 years or 36 months. And that's the one that I'm showing you have 654 days plus. So if you got 3 years on the 24 CR 937
Okay, none of this makes this inmate happy. Give it a second. Here we go.
case, you're not going to get as much pre-sentence confinement credit for that case. You would
So-
just have from September 10th.
From September to now?
Yeah, so it's like a little over 90 days.
Okay, that's not what was explained to me.
Okay.
I was told I would get credit for the original cases, and I've asked twice about it. And I
Yeah.
was told I would get credit from the entire case would apply to the new charge.
Okay. Yeah, so but the new charge, it could be less time too. So I may not impose 3 years. So,
Well, I was told that if I had the 700 days, that would be applied to the new case.
oh, okay.
I wasn't,
Gotcha.
I specifically asked this, does this compute from just the time I've been arrested on the new case, and I was told that it counts for the original 700 days, and that's,
Okay. Yeah, so you wouldn't get the 700 days for the newest case.
okay, I didn't agree to that. And I
Okay.
had asked this several times and it was explained differently.
So how do you want to proceed today?
I didn't agree to this because that would mean minimum would be 15 months and I've only got 3 months credit, correct?
That's how I've tried to explain it.
That
You're
was
right on
not,
this.
that was not explained and I asked several times. I want to do a status counsel. She gave me wrong information and tried to get me to plead to this when I asked several times if that's what it was, and she told me no.
Okay. So that wouldn't be a reason for me to appoint new counsel for you, Mr. Solis?
Well, I want to do status counsel, please.
Well, we can just do it right now. Why do you think I should appoint you a different lawyer?
Because she's providing bad information and attempted to get me to plead guilty today with what I believe was intentional confusion, making me believe I would have 700 days served when she should have known it would only have been 3 months. And then I would have believed that and went to DOC and been told, oh, well, you actually have only got 3 months on this. And I would have been sitting there and been like, well, she told me I was done. I just see that as ineffective and malpractice.
Okay. Well, that's not a reason, as I mentioned to you, to appoint
Malpractice is not a reason to kick a lawyer off your case.
a new lawyer for you.
If malpractice kicked the lawyer off your case, all lawyers would be kicked off all cases.
And that's why I have this discussion with people too, to make sure we're all on the same page. Because sometimes people can hear things differently, or I don't know.
She told me in our last meeting that she believed I should be done and that I would get the full 700 days applied to the new charge.
Okay, you mentioned that before. Is there anything else you want to tell me about that, or?
I want different counsel appointed.
Okay. I'm not able to appoint new counsel for you based on that.
I want a motion for a mistrial for ineffective counsel for being lied to and malpractice for my attorney.
Yeah, and I don't have the authority to do that either, Mr. Solis.
Okay, I don't know how I'm supposed to proceed. My attorney's not helping.
Well, do you want some more time to speak with her, or?
I don't know how to proceed. I'm not an attorney. I'm not being difficult. I don't know how I'm supposed to proceed.
Yeah, so I corrected the misunderstanding that you had, and you haven't agreed to anything at this point as far as a plea agreement. That's why we have this hearing. So I can make sure that you understand everything correctly as I understand it to be. And it sounds like you didn't, and so maybe you might need some more time to think about the plea agreement.
I don't want to agree. I want to enter a plea of not guilty by reason of mental insanity. Not guilty by reason of insanity. That's what I attempted to input. And she presented this and gave me the wrong information. And I believe she did it on purpose in an attempt to have me go to DOC and then have me get different information than what she told me.
Okay, well, it's very complicated to enter a plea by not guilty by reason of insanity, so I'll need to schedule you for a different hearing. And then that'll give you some more time to speak with your lawyer before you would do that. It has a lot of consequences, Mr. Solis, if you were to plead not guilty by reason of insanity that you may not realize at this point.
I went through all the information on my own.
Okay.
NGRI, not guilty.
I read a book, Your Honor. I read a book. I know.
My public defender has not helped me the way she should at all. She hasn't answered a single question. I've left over 100 messages on the public defender's phones, my
Stalker.
messaging system. She did not answer my last question. They've not answered any of my questions in 2 years. And they're giving me false information like on this.
She's just sitting there beside him saying nothing. Okay, so you know how laid back and chill this judge is? The reason why this judge is so laid back and chill is because he was the judge for the mental health court for many years. And if you can imagine what that court must be like, the people who come in front of him are, have severe mental health issues. So he's heard everything and he understands how to keep everything calm. Repeat everything back to the person that they need to hear. So, they need to hear that the judge is listening no matter what, because as soon as they think that no one is listening to them, it starts to escalate and spiral. So, this judge is really good at that. He's very chill. He repeats it back to him and he tries to keep it laser focused on what's in front of them and proceed the best way he can. So that's what he's doing. He doesn't think this insanity plea is going to go anywhere. But that's where they're at right now, so that's what he's going to do.
So I can bring you back on January 21st for the not guilty by reason of insanity plea hearing. I have time starting at 10 o'clock that morning.
I would like to motion mistrial for you guys have delayed this intentionally to violate my right to a speedy trial, including my attorney. I believe you guys are using delay tactics to violate my civil rights for speedy trial, as well as not let me enter a plea. My attorneys lied to me. They haven't answered any questions. I want their motion for mistrial as well for ineffective counsel, malpractice, and I want to file motions for appeal on the original cases because NGRI should have been entered to begin with, and my attorneys, the public defender, are not doing their job, period.
So will January 21st at 10 o'clock work for the
May I write this down?
NGRI hearing?
That works for me.
Okay.
And I'm also available.
Oh, great. So I'll schedule a half an hour for us, Mr. Solis, on January 21st at 10 o'clock in the morning.
At what time?
10 o'clock, sir.
Okay, thank you.
You're welcome. Thanks. And then you may want to try to work with Ms. Parham in between now and then.
She just lies to me. Why would I work? I'm asking, why would I work with a defense attorney that lies to me and sits here and treats me this way and doesn't answer a single question?
Do you want these papers?
Yeah.
So they were both good. His attorney and the lawyer were and the judge were both good with him because he was getting more angry and more angry. So if they would have handled it differently, if they would have pushed back at him, if they would have came at him like he was coming at them, this would have escalated a lot. But they didn't. Everything stayed cool, calm, and collected. Guys, thank you so much for coming out today. I really, really appreciate it. I shall see you again soon. Bye.
Got these life echoes, digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted charm. In a way, there's no alarm. Freedom tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Her eyes hear a sky so blue. In her jokes, there's a truth so true.